Oh, one sec. I can't hear you. Let me figure this out. Audio.
No, it's my fault because I had myself fucking muted. What's up, bro?
I thought I just set my audio device.
What you doing, buddy?
Not much. Just working. But
Enjoying your time out from Twitch?
yeah, I mean, I didn't really have much of a time in. I
Why
got
is that?
banned like after 3 streams, but I didn't. It's because I got banned for something when I wasn't streaming. I was like I said, I was in a chat and not allowed to be funny anymore. Comedy is still illegal, even though Trump is president. Crazy.
As it pertains to the French, that is absolutely true. So mind your fucking business and watch your fucking mouth when it comes
Yeah.
to our noble allies, the French.
I knew Trump was still a fucking foreign shill, just like the rest of them.
Yeah, I mean, like he and Macron are well known buddies.
Yeah.
Set this up. Yeah, it's funny. I fucked up the time on this so bad. Yeah, it's just whatever. It's been a blur. Today's been crazy. Let me set this up because I'm trying to be really strict with my time. So I am gonna
Yeah, no worries. I feel you on that.
throw up a timer. Yeah, the problem is like I've got a really bad habit of spreading myself too thin. Like a really, really bad habit, and I've got to get out of it.
Because you've got like a day job too with the content stuff, right?
Oh no. I know I'm full time. I've
Okay.
been full time, but I do I do 5 to 7 videos a day, and I'm a one man show. So I do all my research, recording, editing, thumbnail and SEO, and then on to the next one. So it's a lot, and plus I do live and learn, and
Yeah.
just got married. I try to have a life. I try to have a fitness routine, and I try to have a social life, and it's a whole fucking thing. So
Yeah, no, I feel that.
okay, so look, so what prompted this is, well, actually, why don't you go ahead and introduce yourself to people, because I'm going to leave the VOD up, just in case they're not familiar with you.
I'm Jebtan. I'm not really a streamer yet, but I've played around with it. But conservative, I've been on the panel circuit forever now, like 2 years, just arguing as a conservative. But generally, my flavor of conservative is just like small government, pretty classic conservatism, not really the Trump stuff. My first election that I really had to pay attention to was 2016, and I was kind of a Tea Party, Ted Cruz supporter type dude. So, not sure if that's a preferable flavor to your audience, but
I think Ted Cruz once upon a time would have definitely been preferable, but the Ted Cruz of today is a fucking loser. So,
sure,
yeah,
I'd agree with that probably.
So what's funny is in the interactions that we've had for the longest time, I thought you were a lawyer, which is actually, it goes to, I think it's testament to how good of a debater you are and how well you represent your views. But for the longest time, I was like, this guy's a lawyer. And then when you told me you weren't a lawyer, I was stunned. And I'm still not entirely sure that you're not a lawyer. I think you might be lying to hide your power level. But that's an endorsement of how sharp you are. And I definitely respect your views on this, which I'm kind of surprised. Especially with you being a small G government conservative, that you support the Trump immunity decision. And I should tell you, like right out the gate, my respect and my affection for you notwithstanding, if I seem pissed during this conversation, it's just because I'm pissed at the decision. I genuinely believe that this is a horror show. And I'm with a bunch of other constitutional legal scholars like Akil Reed Amar, who says it's one of the worst decisions in constitutional history. That's how I feel about it. But why don't you make the case, and again, this is, to me, it's not a debate, it's just a conversation, especially because we're not lawyers, why you support the decision.
So for me, I guess I should clarify, I wouldn't mind an amendment to the Constitution that clarified and narrowed presidential immunity. It's not like the presidential immunity in idea that I support. I've heard good arguments for it. I don't outright not support presidential immunity, especially in like certain cases. But I think Trump's a good example as to why we should probably have a constitutional amendment to clarify where it ends. I was surprised, honestly. Not surprised, because obviously there's going to be people, once an issue actually becomes real, who change their opinion on it because, whatever opinion they had on it before was probably not as seriously held because they hadn't really had to think about it. But I remember seeing like all over like news outlets and pundits and people constantly saying like, yeah, we don't know, presidential criminal immunity hasn't been tested yet, but it's assumed by most legal scholars that it exists. And that was always what I thought going into the case. So the the decision didn't surprise me at all. And then when I looked deeper into their arguments, it made sense. I'm more on Amy Coney Barrett's side.
That's why I hear from a lot of people, like Ryan Mullally is a big Amy Coney Barrett stan when it comes to this decision.
Yeah.
I think even Destiny, who obviously doesn't like the decision, I think he said that he found her concurrence / partial dissent pretty reasonable. So you're not alone there.
Yeah, and I think maybe if we had a constitutional amendment, right? I'm not saying I would support any constitutional amendment because obviously there are some that would just completely eliminate it. I would, if there was something to model it after, I think her concurrence would probably be what I would model it after, where you clarify what immunity means and the process through which they can get stuff thrown out based on immunity. I know for her it wasn't a prescription; it was a description of what she thought currently existed. But sometimes we can clarify things that we think exist, and it makes them stronger. But yeah, so I think presidential immunity exists primarily because I think Fitzgerald Nixon was properly decided, and I think that because he has civil immunity, I think it only makes sense that he would also have criminal immunity, since the burden for civil is almost always lower. And I understand the argument that because the burden is lower to bring a civil suit, that's why he has that immunity, is basically so he doesn't get harassed out of doing his job. And someone brought up a good example, which was another executive example, which is qualified immunity for police. Now, in my opinion, I don't think police should have qualified immunity, and I don't think it's constitutional that police have qualified immunity. But let's say it is. Why would that be different? I would say that because of the strict and specific policy that police are expected to abide by, the president doesn't really have that. And it's almost encouraged for the president to sort of act in a way that, is creative and is innovative and is, pushing the envelope in some points. And so I think that the president does need criminal immunity, because it would be a lot easier to, if he has civil immunity, it would be a lot easier to bring criminal charges against a president for things that you just wouldn't, a normal person wouldn't have the opportunity to do, even another executive, because they have policies that keep them from acting in those ways already. So far before you deal with criminal charges, there's already a chilling effect on that behavior for those executives, because they know they can get fired for breaching policy. Whereas the president doesn't have that chilling effect. It seems like we see a value in the president not having that chilling effect. And so I think criminal immunity makes sense.
Yeah, so it's interesting. I guess I'll address the specific civil immunity situation, because the way I see it, I mean, there are a lot of things, because I even think the premise of presidential immunity is absurd, at least from a quote unquote originalist lens, because,
Sure.
the founders and the framers just waged, a revolutionary war against a distant monarch. And their primary concern, if you look at the Federalist Papers and the ratifications debate, they had many concerns, but their biggest concerns, if you had to rank choice vote them, the number one was, don't make a too powerful chief executive. That's number one on the list. And so it seems to me, that's just from the very beginning, especially coming from like conservative originalists, which I'm not necessarily saying you are. I know Ryan is and a lot of others are. It's just like they explicitly write in a specific immunity for senators and representatives, but they didn't write one for the president. And you're telling me that these people who feared an unaccountable chief executive above anything else wrote in invisible ink that the president is basically a diet king with the sweeping criminal immunity. Like, the premise is absurd on its face. But I do want to address like the civil immunity thing, because I know like a lot of, again, like Akil Reed Amar and some other original scholars, they disagree with Nixon v. Fitzgerald. But I think even if you grant Fitzgerald as being properly decided, I don't think it necessitates criminal immunity, because, like you said, it's vexatious civil litigation is a lot easier than criminal litigation. And just really the threat of civil litigation, period, is just much more common. I saw somewhere, it was like 2021 or 2022, in federal court, there was like 250,000 civil cases filed in federal court, like in 2021 or 2022, compared to like 70,000. So it's just less probable out the gate. Then you also consider that when you're facing criminal prosecution, it's like for each charge, it's a specific charge for a specific jurisdiction. Not that you can't have concurrent prosecutions, but it's nowhere near as sweeping as civil litigation. Plus, you have to impanel a grand jury. You have to go through DOJ guidelines, which require like robust safeguards. You can only bring a certain case if it meets this, and this requirements, just not done willy-nilly. You've got, like other safeguards as well. The burden of proof is higher, for example, in criminal cases compared to civil cases beyond all reasonable doubt. The burden of proof is on the government in that case. They can appeal to like public, it's like public official or public employee exemptions for like specific acts. And then they can appeal, right? Even if like you convince a jury that the person is guilty, that the ex-president is guilty, then they can appeal the case and it could even go before the Supreme Court. And I don't have it on hand, but I know it's either Sotomayor or Jackson lists like the long list of like the steps that a criminal prosecution to be successful would have to navigate that are infinitely more robust and complicated than civil litigation. And so to me, I find that persuasive. I would also point out, like, I think the cop example is a good one. I understand that it's not quite the president, but you are right to identify a cop as an agent of the executive. And so we've accepted as a society that we want cops to be able to enforce law without being, as you say, harassed out of their jobs. But we also don't want to give cops basically blanket immunity, and we know why, and I'm sure you would concede to this. The reason that they have qualified immunity but not criminal immunity is because there's a public interest in having lawful cops and not lawless cops. And so it seems to me that wouldn't that expectation scale to the president, the most powerful, because of the president's power, he's infinitely more dangerous than any cop or probably any group of cops, right? So, and I guess I'll close with this. Like this goes to part of my issue with the Trump v. United States decision, which is that Fitzgerald had a balancing test. The intrusion on the executive's official acts, like you don't want to unduly intrude on the executive, but you also have a public interest as well. And so Trump v. United States totally sidestepped that. It's actually kind of fucking annoying because they cite Fitzgerald more than anything, more than Youngstown Steel, but they actually don't address the balancing act. They don't get Roberts doesn't address, okay, the public actually does have an interest in not having a rogue and unaccountable president. And here's why we don't think we have to worry about that. So what do you think about that?
Yeah, I mean, I get, so to stick with the police metaphor, and then I'll jump into the balancing test. The police one, the reason why I think the president will get treated differently is not just the fact that the president is not expected to act within nearly as strict a bounds as the police are. But he's also levels of abstraction away from his impact. So like when he directs an agency to do something, he does that through an agency generally. They have to have, their leadership align with it, then they have to implement it, et cetera, and so on. I think the Supreme Courts understand that, and I say Supreme Courts because obviously a few have looked over immunity, this one and the one during Fitzgerald and Kennedy. I think the level of abstraction kind of provides a little bit of cushion essentially to the impact, because you need not only the president that can stay in power after doing something that's against the public interest, you also need alignment throughout all of his agencies and whoever needs to enact his power, right? Because you need an enforcement mechanism. And I think because of those levels of abstraction, you don't necessarily need the president chilled specifically by the issue of criminality. He'll be chilled by the issue of, most presidents will be chilled by the issue of people just not listening to them and not doing what they ask. And then as far as the balancing of the public interest, I don't love the balancing of the public interest in Fitzgerald and Kennedy enough to think that it needs to also exist for criminality.
Really?
Yeah. Because my issue is, if we're saying that the purpose of the immunity is specifically to avoid, chilling effects on the regular functions of the executive branch. So like, avoid Obama being able to be taken to court for war crimes when he does like a pointed strike and there's collateral damage, right? Things like that. I think a balancing of the public interest gets dicey there, because whose public interest, right? It's just the Americans' public interest? Well, the Americans it's basically like, as long as you're only committing crimes overseas, the American public interest likely will have a really high tolerance for your criminality. And so in that balancing act, you're going to get treated differently than somebody who does who commits crimes at home.
Well, I don't think the balancing act is about the specific act per se. So, like to use your point with President Obama doing the drone strike abroad, I take your point that the American public would probably be less concerned, I suppose, about the president doing something illegal abroad. But I think a prosecutor who would try to make that case against Obama would say, but the person who was killed by Obama was an American citizen, like in the Anwar al-Awlaki case.
Yeah.
And I imagine most American citizens would be like, oh, well, when you put it that way, I do think there should be limits on the president's ability to, or rather that I think that there's a public interest in understanding the limits and creating limits to the president's ability to kill American citizens, whether domestically or abroad. So I don't know if I buy that per se, that, and moreover, I think it's just the public interest in a generally lawless president. So there might be lawless actions or criminal actions taken by a president that the American people might not give a fuck about or give less of a fuck about. But I think in the abstract, if you just said, I mean, there's a reason that the polling on this is so atrocious. I mean, even most Republicans, it tends to get higher when you say Trump as opposed to presidents in the polls. But most people don't support the idea of a criminally immune president. And I think that that's reflective of a public interest in not having an unaccountable chief executive.
Mm-hmm. Yeah, I mean, so one of the things I think is important to discuss when we talk about like balancing public interest in general is I think the reason why it exists broadly in the civil immunity case as well. One of the things I just thought about while you were talking was right. A lot of the examples for civil immunity are again like passing a policy or through executive order or something, right? That just completely robs a bunch of people of land, let's say. I just think, again, kind of like what you were saying, a violation of sort of mass public interest is a lot more likely to happen in a civil scenario, specifically because we're just talking about monetary damages, which again are, like you said, are kind of a lot easier to achieve. Whereas the public interest scenario, if we look at the Trump cases that would apply, right? Because New York wouldn't apply. New York was him acting as a candidate, so he wouldn't have immunity for that anyway. That's one that I think would absolutely.
I mean, he tried to claim that it was that there were official acts, but yeah, I agree.
Yeah. I think the one he would have, most people agree he would have absolute immunity on, is his pressure on the DOJ to investigate and prosecute, specific people. I don't think that him pressuring his DOJ to investigate or prosecute people necessarily is something that, again, the things that are in his preclusive and conclusive authority are really unlikely to fail that balancing test, I think.
Well, we don't know because Roberts didn't even. That's my frustrating thing is, I personally reject the notion of presidential immunity as a concept, but the issue that I have with this opinion isn't just that it came to a different conclusion than I did. I think it did it in the worst possible way. For example, maybe you're right. Maybe a federal court somewhere or even the Supreme Court would say, hey, listen, we did the balancing act on this and we're weighing the public interest in not having a lawless president either in the abstract or in these specific violations of the law, like the fake elector scheme or ordering sham investigations of his political opponents against the need to have a robust, vigorous executive, and you don't want to intrude unduly. I would at least have an easier time coping with it if Roberts gave any deference to the balancing act at all, but he totally sidesteps it, makes no reference to it whatsoever, which is incredibly frustrating and also weird given that, again, Nixon v. Fitzgerald, that's at the heart of Nixon v. Fitzgerald. That is critical to the decision. It's not superfluous. And Nixon v. Fitzgerald is the foundation of this decision more so. Again, I know Ryan appeals to Youngstown Steel, but Fitzgerald is cited more in this opinion than Youngstown Steel. And so I would still disagree with you even on that front, but they don't even take it as far as you did there. You at least say, well, a lot of these instances it would probably fail that test. He says you don't even have to take the test at all, which is really weird. And to me, the other thing I was going to say with respect to we were talking about the cop thing. You said you began talking about the cop situation, which is that You said the police, have to, that they're having to operate within confines that the president doesn't. But I think that goes to the heart of this, which is that prior to this, there was the expectation that the president, yes, might quote unquote push the envelope, yes, might quote unquote get creative, but that he was still expected to operate within the confines of the law. And I mean, we could even use past examples. Take Trump out of the equation. To me, what was stunning, another stunning part of the Trump United States decision was that, people who were still alive or are still alive who were involved in the prosecution or investigation of Watergate, they were like, this decision, like Nixon would not have resigned if Trump of the United States had been understood to be the law of the land prior to Watergate. He almost certainly would not have been able to be prosecuted. And he could have gone further, like he employed, campaign staffers to break into the Watergate Hotel. He could have just ordered the FBI to do it, and,
Sure.
and you also mentioned that there are layers of abstraction between the president and those carrying out his orders. I'm not sure I buy that as sufficient reason to believe that Trump should be, or that president should be entitled to presidential immunity, because the expectation is that when the president gives a lawful order, it will be obeyed. And if people don't obey his orders, he can fire them. I mean,
Sure.
Are you a veteran? I thought you were used to be in the military. Do you?
No.
No,
I
see, there
just
again,
didn't-
I'm just making all
so
sorts of fucking
no,
assumptions about you.
You're not the only one who
Yeah.
does that one. I think the hat and the constant green T-shirt wearing kind of, and the fact that I'm a clean-shaven white guy kind of.
See, I just made, again, I built this whole fucking profile for you behind the scenes. I'm like, listen, so Jeb Tam was obviously in either the Army or the Marine Corps, and
then
he, at
became
one
a
point, he
lawyer.
went to JAG, right? He was like a JAG attorney.
Yeah.
But yeah, so
Take that backstory over mine.
yeah, well, this could be your comic book origin story, definitely. But yeah, I find that kind of unpersuasive. So
I think the levels of abstraction is also an important part too. So like the reason why I would be less likely to give a police officer criminal immunity is because when a police officer is being prosecuted criminally, it's going to be directly for things that police officer did, right? At most, a police officer would be getting in trouble, like a chief of police could maybe be getting in trouble for something he commanded a direct report to directly do. Whereas a president, if not given some level of criminal immunity, and this is one of the good arguments I said, because I'm kind of with you where my natural sort of patriotic yearning is toward that of a non-immune executive, civilly or criminally. But some of the good arguments I've gotten is like there's stuff that presidents could get prosecuted for that happened like 4 or 5 steps in the chain beneath them, especially in the terms of civil liability, simply by not being clear in a memo or saying something that could be persuaded, it could be seen a certain way in a memo as a direct order to do something that ended up being illegal. Whereas like you're not necessarily going to have that in the case of a police officer. They're usually directly doing whatever crime it is they're getting prosecuted for. And so I think that's where I agree that there should be some level of presidential immunity.
So can just to clarify, so what you mean is you're afraid that in the absence of immunity, if some sort of subordinate officer of the president commits a crime, that somehow the president himself could be criminally culpable for that by either by association or simply because the criminal reports to the president, or perhaps the president was vague in an instruction, so the subordinate does something illegal. I'm not a lawyer.
I'll use the Obama example
Sure.
again, right? So like, if you wanted to prosecute Obama for the collateral damage because he approved a strike, at the end of the day, I don't expect every president. There are some presidents where you'd expect it, but I don't expect every president to be able to walk in with enough know-how to understand perfectly every strike that they're approving. But he approved a strike that directly killed, like, I believe, an American citizen.
The Anwar al-Awlaki. I'm thinking butchering his name, but yeah.
But I am one of those people on my side of the aisle where I'm like, I don't think he should get prosecuted for that, because at the end of the day, like sometimes you're going to get bad intel, sometimes you're going to do a bad strike, and that again, it's part of the core.
But here's what I would argue. But I take your point. But here's what I would argue. That situation happened prior to the Trump v. United States decision, and no prosecutions were ever brought against Obama in that case. And it might just be because there isn't a prosecutable case to make. I mean, simply because an American citizen died as a result of a drone strike, that's not inherently prosecutable, right?
Well, a lot of people also said that there are a lot of legal scholars. I think Just Security did write about it, where like one of the stronger arguments for this sort of being not like mass 95% consensus, but at least general legal consensus. That was one of the cases that clued into them that, that was probably not prosecuted because they didn't find it worth the time because they figured it would end up being unprosecutable based on presidential immunity. And so, but I would agree with that. Like, I would agree that he probably shouldn't, because at the end of the day, he's not the one who collected the intel. He's not the one who performed the strike. And at the end of the day, he can't control for the quality of every person beneath him that gathered the intel and then performed the strike. So, like, in that case, I think that was bad intel, and it was a direct strike. They hit who they meant to hit. It was just the wrong person.
Well, yeah, but I mean, like, and again, I know it's not quite analogous, but I'm thinking of like self-defense or justifiable homicide, things of that nature. I mean, simply because you take a life doesn't mean necessarily, number one, that you will be prosecuted. Number two, even if you are prosecuted, that it'll be successful. And in the case of the president, again, I take your point that these people are not polymaths in the sense that they rely so much on chains of information, chains of custody, and expert advice. But part of that expert advice is the White House counsel and DOD attorneys and things of that. So presumably, I mean, I don't know the vivid details of the Anwar al-Awlaki case, but my expectation is that Barack Obama did not wake up one day and said, vaporize this fucking loser. He probably consulted with all sorts of lawyers and were like, okay, what's the risk assessment here? What are my legal authorities? Obviously, this is an American citizen, but he's a suspected terrorist. To what extent do I have the power to, in my national security prerogative, to take that life? But I don't think it's so much presidential immunity as it is the president is just allowed to do authorized things. It's not that Obama committed murder and is somehow immune for it. It's just that it's kind of like, again, law enforcement, cops, right? They are allowed to kill people during the course of their duty. Now, there are parameters for it. And we like knowing that police officers, if they, just murder somebody, that they can be held criminally accountable. But again, I don't think we frame that as a level of, that's police immunity. They have no immunity.
And I get that, right? Because immunity, what people think about, right? And it's an important thing to think about. When you are giving immunity for illegal actions, and that's mostly what people think about. But when you look at the actual decision and the purpose of the immunity, the actual purpose of immunity is primarily to cover actions that probably wouldn't, in the end, be convictable. But you can't really tell that until they've been tested. And so you need to give him that, kind of the way you said it. You kind of just need to give the president the ability to do the official things without it being legally questioned, because otherwise there would almost always be standing in cases like that Obama one to bring a suit, unless you were pretty certain that you just straight up can't. Straight up can't.
Well, I should clarify. I should clarify, because I'm not saying, I mean, obviously, again, I don't think anybody would deny that in the scope of their duties, presidents have, I mean, any government official, not just presidents, again, cops, just a regular beat cop, has certain authorities and certain authorizations that just, civilians do not have. Again, I don't look at that as immunity, but again, I want to focus on the cop example, because to me, it's so illustrative, and it's something that people like laymen understand on a day-to-day basis. You want cops to be able to, under certain circumstances, kill if they have to in the self-defense or defense of others. But you would never, and nor I think would most people say, you want to give them criminal immunity for discharging their firearm. Like, discharging their firearm is an official act of a cop. Well, no, you would be like, well, it depends on what, when, and how they discharge that firearm, right? Sometimes you would say, no, this shouldn't be prosecuted because it reaches all the standards of, justifiable homicide. And other times you'd be like, oh, fuck yeah. I mean, this should obviously be simply because the problem is, I would argue Trump v. United States doesn't do anything analogous to the example I just laid out. In this analogy, the president, quote unquote, discharging the firearm, simply by virtue of him discharging the firearm, is an official act for which he can't be prosecuted.
For some things, right? I think the absolute immunity is very narrow. But one thing I would say that kind of goes to the Fitzgerald-Nixon aspect of it is the reason why we're kind of okay with the cop having to go through those legal barriers, right? Is because a cop can only be criminally charged, by his jurisdiction, people in his jurisdiction who were direct parties to the crime, et cetera, and so on. The jurisdiction in terms of who could prosecute the president for any number of official presidential acts is essentially the entire country. I mean, depending on what official act you're talking about,
Well, yeah. Can we just
Yeah,
clarify that, because it's like the Georgia example. So that wasn't a federal prosecution, that was a
yeah,
state prosecution, but like Nebraska couldn't have
yeah, for that specific
prosecuted
one.
Trump for Georgia, right?
But it's like, say, the pressure on the Department of Justice to investigate and prosecute. Say a president earnestly thought, there were people that needed to be investigated and prosecuted, and it was a number of representatives from a number of states. He could get, or he just said, "Hey, well, let's investigate all of, let's say my own cabinet. Let's investigate all of them because I don't know what they're doing behind the scenes, and people are saying that my administration is doing crooked shit." Well, that could potentially represent people, following and investigating people across a number of states as they travel in DC. He could be tried in DC. He could be tried in someone's home state if he investigated them improperly in their home state, et cetera, and so on. And so I think for the same reason as Nixon Fitzgerald, you have a much lower burden in terms of determining who has standing to try and prosecute the president. The false electors scheme is a good example of where, one, I don't think it's covered by this immunity. That's unofficial conduct, in my opinion, almost cut and dry. But like the pressure on Mike Pence would be a good one, where, who has standing to prosecute him for that? Is it just DC?
Well, and that's the thing. Like the fake electors plot, he was prosecuted by Jack Smith, so special counsel.
Yeah.
There was a RICO case in Georgia, and again, so different jurisdiction. But like even the fake electors have been prosecuted in the fake elector states, and I don't think Trump has partied any of those lawsuits, to my knowledge. So it's not like, and I can't remember what all the states are prosecuting the fake electors, but I don't think, let's just use Colorado as one. Like, I don't think Colorado is prosecuting Trump for the fake electors plot. So I listen.
Man. I want him prosecuted for that everywhere.
Oh no, yeah, and listen, that's why I wanted to have the conversation with you, because I know you're not a Trump guy, and you've been pretty principled on that, and that's what I mean. It's like it's a bit confusing for me to square your small government conservatism with the immunity thing, and I appreciate you being very candid about how you do have misgivings about it, and aspirationally you probably lean that you don't like it.
Your balancing act argument is a good one, and I could even concede that should have been in the decision. It doesn't push me all the way to the decision was catastrophically wrong, though.
Let me ask you that. Let's talk about the catastrophe thing. Okay, now listen, full disclosure, I'm a cynic. Are you a cynic? An optimist? What are you?
I'm kind of in the middle. I hate that because everyone's like, I'm a realist. But like, I'd say I lean optimist.
Okay.
Things tend to turn out.
Is this glass partially full or mostly empty to you?
Yeah, that glass has enough water to quench my thirst.
Oh, see? All right. Okay, there we go. That's illustrative. I appreciate the concrete example. Yeah. So I assume, here's my thing. I fear the worst case scenario, and I'll explain why. And to me, I'm consistent in this. Joe Biden was president at the time this case was decided, and there was no guarantee that Trump was going to win election, certainly after Kamala became the nominee and Biden dropped out. The thought of Joe Biden or Kamala Harris or Barack Obama being the recipient of presidential immunity makes me fucking sick, and I say that as a partisan Democrat. Mm-hmm. I don't trust my side with that level of immunity, and I certainly don't trust the Republicans. And what was interesting, as a sidebar, I felt that so many Trump Republicans, by the way, I don't know if you noticed this, told on themselves when that decision came down, because here, the Republicans, the Trump Republicans, the MAGA Republicans were saying at the time that Joe Biden's a real threat to democracy. Then you would think your sphincters would be clenched in terror if you thought that, that the red background fascist Joe Biden at the Independence Hall is going to be in office at least for another 6 months. He's already the most powerful man in the world, and now he has criminal immunity. The fact that you all celebrated, and not you, you understand what I'm saying, MAGA. The fact that MAGA celebrated that decision instead of like quaking in terror, to me is like, okay, you didn't actually believe that the Democrats were the fascistic threat you claimed. Yeah. But I was concerned, even though Biden was the recipient of it at the time, because it's like, to me, again, it's just, I fundamentally reject the premise that this is at all American or what the founders and framers intended. There's so much evidence that they didn't. We have quotes from essays and the Federalist Papers and the ratification debates where, like, Iredell, one of the first Supreme Court justices, was like, yeah, presidents can be prosecuted. I mean, the quotes have ever, there have been amicus briefs filed in the Trump v. United States decision. The abundance of the historical data sits squarely with the founders never intended for presidential immunity. And they knew about it because executives, state governors, a couple of them, had immunity in their state constitution. So they knew about it, and they knew sovereign immunity from King George III.
Sure.
And they did grant immunity for legislators, very specific, narrow immunity. They did not even touch it for the executive. So, like, to me, any originalist who's like, yeah, it seems pretty clear the framers, like, fuck off. That's obviously not true.
Yeah, I mean, I would default to Ryan about that one, because he and I had we had a back and forth on Twitter right before he had a conversation about it with somebody, and I watched it. I listened to more of his, and he's got more of the information. But I think there is an originalist argument for it. But
but it's in the structure, because I've heard Ryan, because Ryan and I had this conversation too.
It's in like frameworks and the way that prosecution has been handled with presidents in the past, I think is where it lies. But I think people say originalism and they think it has to be direct text from the Constitution, whereas originalism is more you're surmising the intent of the founders based on how they behaved, and when you don't have law, right? It's like a hierarchy of evidence thing. Obviously, constitutional text beats out everything. If you don't have,
we do this? And let's do this in order. We agree that there is no text in the Constitution which explicitly notes presidential immunity. Okay.
Yeah, no, 100%.
So then the next level?
So the next level, I think, would be surrounding legal frameworks that don't explicitly give whatever it is you're talking about, right? But they seem to consistently apply the same principle to so many similar cases that this would necessarily be the case. I don't know that. I think some versions of I think absolute immunity doesn't fall under this, but I think presumptive immunity for official acts definitely falls under it. Seems as though there are a lot of legal frameworks within the Constitution and different law and the way prosecutions have been handled that.
Can I push back on that for just a second?
Immunity is a thing.
Can I push back, because you said some interesting things there. So again, we agreed that the explicit text of the Constitution does not note presidential immunity. So then we look at the next level of originalism, which is there are two parts, like what the framers of a law intended and what was publicly understood at the time. Yeah. And I've seen no evidence, none, and Ryan's never offered any, that the public understanding at the time of the ratification of the Constitution is that presidents were immune, because to the extent that there was public understanding, we have the words from the framers and the founders and the influencers at the time, again, from the Federalist Papers and essays and ratification debates and delegates who not only participated in the Constitutional Convention, but then had to go back to their states to make the case, hey, listen, I was at this Constitutional Convention, here's why we should ratify. And there are many instances where delegates and framers were like, we discussed immunity. And the president, one of the things that separates this president, the chief magistrate, from the king, is that if the magistrate violates the law, he can be held accountable. I think, again, it was Iredell, who was one of the first Supreme Court justices. He even said the president could be executed for violating the law. I mean, like, it was understood at the time, to the extent that there was any understanding, any. I don't know what the average person, in 1789 America thought, but in terms of the people who had opinions on this and who shaped opinions, it was very clear that the president could be prosecuted for crimes. Plus, it also says it in the Constitution. That's the other thing. I would actually say that there's explicit text in the Constitution which permits presidential prosecution, which is the impeachment judgment clause, which is after a person's been impeached, they may be prosecuted, they may go to trial and everything else. So to me, I understand, like, Ryan, I think, is very clever because he appeals to the structure of the Constitution because he knows the text isn't there, and he knows the framers and the founders.
Well, I think to just jump in real quick before you finish that point, I think the originalist argument for it is the one that Fitzgerald used, which is that the separation of powers cannot remain intact if the legislature and the judiciary can operate together to suppress the executive's power.
Can or cannot? Can you repeat that? I'm sorry.
It can't be left intact. Like, the separation of powers could be violated if the legislature and the judiciary are able to make an official act illegal and then make an official core preclusive, presidential authority act illegal and then prosecute him for it. you then don't have a separation of powers, because now Congress and the judiciary can effectively control what the president does if they have the ability to make his core constitutional authority illegal without actually changing the Constitution.
I mean, I guess what I would appeal to are, again, other original scholars like Sai Prakash or William Bode, is one of the Heritage Foundation originalists, and again Akil Arid Amar, who say, the idea of let's use bribery as an example, like pardon. The pardon's the easy one, so specifically enumerated power.
Yeah.
I agree with you that it would be on its face unconstitutional to create a law that says the president can't issue pardons. And Ryan has other examples. What if they say you can't do official acts on Sunday or whatever? And I think that would have to be litigated. I would agree that shouldn't include the president's pardon power because it's plenary. But what about pardons for corrupt purposes? Those same originalists say that there's really nothing in the Constitution or even the structure which precludes criminalizing or prosecuting a president for corruptly abusing the pardon power. He has the power, he just can't use it to affect criminal ends. That's the originalist argument from other originalists, like, again, Amar and Prakash and Bode and everyone else. And more
preemptive pardons, I think, would be something that could be thrown in question there. I know with the Biden thing, people threw out the preemptive pardon is something that maybe we should take a look at, but
I mean, like I'm open to all of that, but
to clarify, I thought it was crooked and scummy. I don't necessarily have a problem with the president having that power.
It's supposed to be a check on the judiciary.
Yeah, I think he should have pardon power after the fact, but I think I don't know. I don't know, like I wouldn't say that because Biden did it, I'm now moved. Now that I've seen it happen, I'm not moved all the way to the side of it shouldn't be a thing. Like I'm kind of in the middle. I wouldn't argue with a law that tries to limit preemptive pardons, but I wouldn't support it actively either. I would kind of I'd have to get argued on either way.
So with preemptive pardons, like, again, if I had my druthers, if I had it my way, no, I don't think that those should be a thing, because to me that's too powerful of a check on the judiciary. I mean, really, the pardon power is pretty potent as is, because it says, listen, a federal court, if they criminalize or successfully prosecute a person, you can just literally snap your fingers and undo it. You can either commute the sentence or you can do a full pardon, release that person the next day. You can neutralize, like, think about it, you can neutralize any federal prosecution in court, and that's pretty powerful. If you can then preemptively pardon people for shit that they've not been prosecuted, self-pardons and preemptive pardons, to me, in a sane, good faith reading of the Constitution, which obviously it's vague, so it doesn't enumerate this, but that's insane. Like, there's this legal principle that no man should be a judge in his own trial, which is basically what a self-pardon would be.
I don't think, that is one thing, and I'm, as not a lawyer, I'm very hesitant to say this. I feel like self-pardon is something that, in my opinion, there's no originalist or living constitutionalist argument for a self-pardon. I don't think there's any understanding in modern times that leads to that being of the public interest, and I definitely don't think there's any originalist argument for a self-pardon. I think what got scary with Biden, even from a non-biased perspective, because if you've noticed, I try to always test these things by looking at someone on the other side.
Right.
I don't bring up a lot of Trump examples because at the end of the day, he's still on my sort of side of the aisle technically. So I always bring up Obama, and I'm like, how would that work with him? With Biden, what got scary, though, even from an unbiased perspective, was the combination of preemptive pardon and sort of blanket. I don't even really need to specifically name pardoning.
It was not just a preemptive pardon; it was sweeping. And I totally listen. I don't think that should be a tool on the table for any president. I think I totally agree, and I would not mind at all a Supreme Court interpretation of the president's pardon power, which says, hey, listen, when the framers intended the pardon power, you should read this as for actual convictions on the record, not preemptive pardons and not self-pardons because of its corrupt implications, et cetera, and so forth. But and that's another reason why, part of my content is I spent a lot of time bitching about even the notion of the Supreme Court. And what's interesting is Trump has put me in an awkward position, but I try to be as consistent as possible, which is I believe the Supreme Court, and again, the founders were pretty clear on this, we don't have three co-equal branches. We have three coordinate branches. The word co-equal is never mentioned in the Constitution.
Yeah.
And Article 1, Congress comes first because they're pretty much always the final hand on top, at least in theory. So the president can veto, but what can Congress do? In theory, override the veto. Can the president override the override? No. Congress is the final hand on top.
Yeah, I think that's good. I think that's a very originalist interpretation too. Like, not saying that you are one, but like that's a strong originalist argument because, I mean, it seems clear the founders' goal was to make every government decision as directly voted on by the people as possible, and legislature is the only one that does that.
100%. And so you don't want to make the court impotent, but I also don't like the notion. I dislike the notion of an imperial Supreme Court just as much as I do an imperial presidency, and so it's definitely interesting in the age of Trump. But the pardon thing, going back to that specific example, set the preemptive and self-pardons aside. One of the specific things that a lot of people noted about this opinion, a lot of critics, both laymen and scholars, is that this decision effectively makes it impossible to prosecute a president for bribery. Now, the opinion doesn't say it's legal for the president to be bribed. Mm-hmm. It basically takes the bullets out of the proverbial gun because you can have the quid and the pro, or the quid and the quo, but not the pro, right? You can point to the public record of the president issuing a pardon. You can point to evidence that they received some sort of money, right, in exchange. But you can't actually probe the motivation for it. You can't elicit testimony. You can't look at private records. So I think short of an actual explicit confession, right? Yeah. There's no way. It's asymptotically impossible to prosecute a president for bribery. And what's frustrating is, conversely, you talk about immunity. I'm curious. Do you like Glenn Greenwald?
No.
You're not a fan of his?
I mean,
really?
I'm a fan of some of his work, but as a person, I think he Trump shilled. He Tim Pooled really hard, and he just kind of joined that crew of just he got very reactionary. And so I haven't, but I respect his journalistic work, especially the stuff that happened prior to, like, I would even say 2020. I think even after 2016, he was still pretty solid. But
yeah. So what's interesting is I'm not a big fan of his either, but I listened to about a month ago. Are you familiar with the libertarian magazine Reason? All of this is relevant. So they hosted a debate between Glenn Greenwald and another legal professor, a law professor whose name escapes me. But she was actually arguing in the affirmative in defense of Trump v. United States, and Glenn Greenwald, not just academically, but apparently he vociferously hates the decision. Now, he's still a Trump shill, and he argues, the cases against Trump were bullshit, and it's no big deal in the sense that this is nothing new. His issue with it is that it codifies a privilege that he felt has been de facto given to presidents for years. So he kind of takes your position, not that it was necessary.
I agree with. Yeah, no, 100%.
Yeah.
I think it has been de facto given, and I think that was why the Supreme Court ultimately felt like, it does seem like this has been the legal tradition. But that's why I would also support like an amendment that clarifies the part, like
the No Kings amendment that Biden proposed, like basically undercutting that.
Yeah, but a little more specific. Like, that's why I said I wouldn't support any amendment, but
gotcha.
I would support an amendment that, for example, says bribery is never an official act of the president. Like treason is never an official act.
Well, but see, that's the thing. So that's what's interesting is they would say, Roberts, if he were here now, would say, Jeb, I didn't say bribery is an official act. I'm just saying that to the extent an official act is involved, which by definition it would be.
Yep.
You just can't probe the motivation. That's I think the really snaky thing about this decision is defenders will say, Jeb, you have nothing to worry about. Bribery is still illegal for the president, and you would come back and say, yeah, but you've effectively made it impossible to prosecute.
I think an amendment that specifically names bribery and says it is not part of his, like it specifically says it isn't, I think will give prosecutors enough wiggle room to be like, well, we at least need to investigate if bribery happened.
Well, Barrett made, what's interesting is Barrett, that's why I'm kind of pissed she did not join the dissent more properly, because she made that point, which is like, listen, you at the very least have to make this possible. You should make it possible for courts, like that the judge can make a determination. The prosecution can say, hey, listen, we believe or we have evidence of improper motivation by the president to do this official act. This is a bribery, and then the judge can make that evidentiary decision. But Barrett notes that Robert completely just kneecaps that. But
Yep.
That's the thing that's frustrating about this is while it's effectively immunized a president from a bribery prosecution, you know who isn't immunized from bribery prosecutions? Fucking judges, fucking Congress people, fucking senators. And this is Glenn Greenwald made this point, which I thought was really good. Man, the court feels a really certain type of way about presidential immunity, and yet senators, representatives, governors,
none of them
judges have been prosecuted for bribery, and their official acts and the motivation have been probed. And so to me, that's what I mean. Like, there's a total inconsistency here by the majority opinion. I don't believe, I would be shocked, but I guess I should run it past this court, that this court would never say, well, no, like Bob Menendez and all these other fucking people charged with acts of corruption, like, of course you should be able to probe their official acts. Why this unique carve out for the president? I just don't think it's constitutionally sound.
Yeah, I think I wouldn't hate, for example, like, because the No Kings one, I'm pretty sure clarified that the president has no immunity for any illegal acts, and that's where I'm like, then he just doesn't have immunity, and then the immunity for legal ones doesn't apply because every prosecutor will just say, well, we're prosecuting him for something we think is illegal, and so you effectively have no benefit of immunity. What I would agree with is maybe an amendment that says the president only has presumptive immunity for criminal actions, which means you can always prosecute, you can always use things as evidence, but there is still a very quick way to dispatch a lawsuit by making that core argument, does it pose any danger?
Can we talk about that? I'm curious, how far does that go with you? Because the language in the case is pretty sweeping. Like, presumptive immunity is the language is something like it can have literally no threat against the functions of the presidency, and I'm like, that sounds like an impossibly high bar. Like, I mean, sure. I'm just imagine what any president, Democrat or Republican, if you try to prosecute him for a bribe under that framework, and be like, hey, listen, so what you're saying is you're probing my motivations for giving pardon, so you're intruding on my pardon power. And of course, they would dress it up in legalese. Sure. And I imagine judge would be like, well, I guess technically at some level that could chill the president's ability to pardon. I think that seems way too high.
This is where I think you asked a really good question with the optimist pessimist thing, because I think judges generally are good actors. I think the Supreme Court kind of proves it, but that's where you and I would probably break because of this decision specifically. But I think if you look at this Supreme Court's decisions as a whole, if you really look at like everything that's been on their docket, they've been super bipartisan. They've been bipartisan originalists, obviously, the people that Trump put on the court. And I think that most judges, if given that argument, would be like, well, very clearly, if it's just presumptive immunity, if you're saying it, like you said, it just involves your pardon power, and so it's going to touch up on your pardon power. I think a judge would have in their, opinion, they would probably say, if we allowed this to be precedent, then we'd never be able to prosecute for bribery ever, and so we're not going to accept that, and we're going to pursue. We don't believe that if bribery took place, it would put a chilling effect on pardon power to be prosecuted for it. And so, and we also don't think, a president necessarily needs his right to receive a gift just before issuing a pardon is something that needs to be protected. And so I think a judge would say something like that. I think most judges would say,
I think it's possible. I want to be clear. I will tell you, with this Supreme Court, I have no doubt that if it were a Democratic president being bribed, I have 100% confidence that the Supreme Court will absolutely vote to prevent that. Now, with a Republican, I don't know. A
lot of even the local judges who prosecuted the Trump cases were Trump-appointed Republican judges. So
that's true, but that's what I'm saying. What I meant with this Supreme Court. Here's the thing. I agree with you. Like, when it comes to the 2020 elections, or like even a lot of the legal challenges Trump is facing now, like he's catching L's in by Trump judges, by Reagan judges, by a lot of conservative judges. So I take your point. I'm just more concerned about the Supreme Court. Like, I'll tell you why, and we obviously don't have time to litigate that thing, but the Anderson Trump case about the 14th Amendment, Section 3 of the 14th Amendment, I think they bent over backwards to avoid an original, just because they didn't want to deal with the shitstorm of, states being able to kick presidents off ballots, and then obviously the Trump v. United States decision. But just to be clear, I totally agree that there, under this circumstance, I still think, yes, you in theory would be able to find judges who'd be like, bro, like, you can't just say, oh, I pardoned somebody, therefore I can do fucking literally anything with the pardon power, because any abrogation of that would intrude on the pardon power, and like, I totally agree. But the fact that it was phrased that way, that's the problem, is we are almost expecting judges at the lower court level to, like, get really liberal in their interpretation of Roberts' very sweeping words, and then we have to trust that once it inevitably got appealed, that the Supreme Court would hold that up. But you mentioned at the very beginning, and I know we got about 7 minutes left, we talked about, like, I can't remember what the word you used, but I think it was either horrible or something like that, kind of the worst case scenario stuff.
Catastrophic, I think.
Yeah, catastrophic, that's what it was. Thank you. And I am curious how you feel about this, because, I listened to Ryan's debate with Pisco last night, and I've talked with Ryan about this before. And I really don't like his views on this, but one thing that I think a lot of people would agree, and this is one of the big criticisms of the opinion, and even by people who support the notion of presidential immunity broadly, is that the parade of horribles, nobody has a good fucking answer for the SEAL Team 6 thing, in my opinion, and I'll explain why. Or the coup. Like, during oral arguments, Trump's attorneys were like, I hope somebody wouldn't do it, but I suppose ordering a coup or using SEAL Team 6 to assassinate political rivals, those could be official acts for which a president's entitled to immunity. And Roberts, in the decision, mocks the concern from the dissenting judges, but he never actually pre-butts it. He never actually invokes a limiting principle.
Mine would be the preclusive principle. So, and I think Ryan does a good job of using different language to make it easier for, like, laymen like me to understand, because I didn't realize what preclusive meant in context until he started saying conclusive and exclusive. What it means is other people, not only can the president do this thing, he's the only one that can do this thing. That's what preclusive means in that context. He's not the only one who can command SEAL Team 6. He is the highest one.
No, he is.
Can command
who
SEAL
else?
6.
Who else can command SEAL Team 6?
His Secretary of Defense can command SEAL Team 6.
Oh, you're talking about subordinates. Yeah.
No, other people can do it. And so, since it's not a preclusive part of his authority, he would only have presumptive immunity. So then you get into that question of if it would impede on his ability, and I don't think a judge would argue that it would impede on the president's ability to be commander-in-chief to not be able to assassinate,
I don't think that follows, though. Well, wait a minute. I don't think that follows, though, because one of the court's determinations was that him directing prosecutions, no matter how sham, was a core function of the executive for which he was entitled not just to presumptive immunity but absolute immunity. But he's not the only one who can direct the DOJ. The Attorney General can.
But I think what they were saying was his specific pressuring of them. But I don't think if they were to have investigated someone in an illegal manner, or if he were to somehow have taken personal part, like a lot of people say, what if the president even grabs a gun and does it or whatever? His personal his personal involvement, I think, would still be considered criminal because it's not preclusive.
No, but that's the thing, that obviously not, because he was personally involved in pressuring the DOJ to prosecute or potentially prosecute people as regards the 2020 election, like sham investigations into voter fraud. But Trump is not. As a matter of fact, it's usually the norm. Normatively, the president doesn't direct investigations and prosecutions. That's the province of the Attorney General, the Deputy Attorney General, and I usually like the FBI Director, Deputy FBI Director. So it can't be, if you're representing Ryan's views accurately, which I assume you're trying to, that can't be the case, because it's kind of one-to-one. So the president runs the DOJ, and the president runs the military. And the idea that we need not fear him invoking the military to assassinate his political rivals or using the military illegally because there's a Secretary of Defense under him. Well, there's an Attorney General under him that runs the DOJ, and the court parsed that away and said it was absolutely immune. So I think the logic very clearly applies to the military as well, even though they don't explicitly say it. I don't think we have any real reason to assume, because the DOJ, fuck, that was a congressional creation. There was no DOJ at the founding of this country until Congress created it, whereas the military is explicitly in the Constitution. So I think to the extent that running the DOJ is a core presidential power to which the president's entitled to absolute immunity, then commanding the military would as well.
Yeah, so I'd have to think about it. I think one of the reasons why that one got laughed at initially, because the thing I just mentioned is something I had only really thought about more yesterday after Ryan's conversation, because like I said, his use of exclusive in place of preclusive was what sort of enlightened me to what preclusive meant in that context. Um, I I really just sort of lumped it all in with conclusive in core power, but. I think the reason people laughed at it initially was just because there is criminal liability for everybody under him, and so it is super unlikely for him to ever do that because they would all.
What if he pardons them with that sweeping pardon power that we were talking about?
Yeah, that's where the sweeping pardon power I think is something that I would want to be worked on as far as preemptive and sweeping pardons. I think direct naming and pardons for convictions would probably be where I would.
Oh, I totally agree, but that's the problem is where we the system in which we currently live is none of that's necessary.
Sure,
and I'll tell you another one that Pisco points out, and this is again what's so fascinating to me about legal conservatism is you're again, I assumed you were a lawyer, so I imagine even though you're not one, this unitary executive theory.
Yeah.
So there's this idea that given that the Constitution clearly creates invests the president with all executive power, that everybody who works in the executive branch, they don't have their own separate authority, I suppose, unless constitutional or statutorily
they have,
determined.
Like, delegated authority from the president. Yeah.
Why wouldn't they have delegated immunity? One of the Watergate investigators who wrote an essay about this, about the Trump United States decision, where he was like, Nixon absolutely would have gotten away scot-free, would have never resigned, because Nixon's like chief of staff, H.R. Haldeman, he would have. Why wouldn't he have also had some degree of presidential immunity because he was just simply carrying out the president's directive? And so that's another thing that obviously Trump, the United States, did not touch, but I think is also interesting to consider in the nexus of all of this, which is that if the president is the source of all executive authority from, the Secretary of State all the way down to, whoever is, sweeping up the shit at the White House, you know what I mean? Like it all flows from the president. Why wouldn't immunity? But even if not, the president could simply pardon that person.
No, and I get it. Like I said, I would be supportive of an amendment that clarifies immunity in the ways that I laid out. But I wanted to touch on one thing before, because I know you have to hop off. Yeah. Was the optimism pessimism thing, because I think that was actually like a really good thing to mention. I want to make a small argument for optimism. Because
it will literally kill me, but I will try. Okay, go ahead.
Here's my issue.
Yeah.
Is I think it will affect how people vote, and I think optimism provides the best candidates, the best policies, and it avoids the scary, do this now because otherwise something terrible is going to happen, because that's how Trump happened. That's how Trump happened the second time. It was always do this now or doomsday.
It may be how Trump happens a third time.
And on the Democrat side, right? And this is where my optimism is sourced from being in Southern California. I'm in Orange County, California. It's a very purple area. Like, I'm represented by someone blue, right next door, someone red, et cetera and so on. And I'm a conservative in Orange County with a conservative board of supervisors, but Democrat mayors all over the place and Republican mayors, and just a lot of mix. And so you see a lot of people working together, and a lot of my close friends have worked in the Democrat Party of California. I know a lot of local Democrat representatives that do a really good job, that really do just want to work and make people's lives happy. And so I've seen it. But then you see at the state level and at the national level, Gavin Newsom, right? He's creating his. I love the Trump tweets, by the way. The making fun of Trump tweets are very funny. They become not funny when he is doing a real Trumpian thing underneath them, which is he is trying to change a constitution to allow him the permanent power to gerrymander.
Oh, I saw this from you. Oh, we're going to have to schedule a second conversation.
This is why I think optimism is important, because he is painting this picture that Texas is going to get these 3 to 5 seats, and they're going to create a GOP dominion over the entire country forever. And so Californians should give up their right to vote, essentially. They should give up their right to a fair elections. They should which he's always wanted to do, okay? Arnie was the one who got that into law in California.
The governor.
Yeah, because he saw this coming. He is principled against Texas in doing it. He's not some hypocrite. I'm principled against Texas doing it. But But pessimism is the only way where you can think that fighting election rigging with election rigging can work. Otherwise, it's better to go into an election that you guys already have a huge advantage in the midterms and say 3 to 5 seats in Texas is not going to beat the
Bro,
Democrats
margins
in
are
the
so
midterms.
fucking. Listen, we're gonna
No,
have to. We
yeah.
have to schedule a follow up on this. I got to tell you too, chat, because again this was unplanned, and I created this landing page very short notice. But to the extent we have a chat, they are all singing your praises even when they disagree with you. They wanna know where they can
I
find
looked
you.
at the chat one time so far, and someone called me Blue Eyes White Dragon, and I've had to stop
Is that
myself from
the Peacemaker
laughing.
thing?
No,
Blue
Blue
Eyes-
Eyes White Dragon is a Yu-Gi-Oh card. It's a,
Oh.
it's a
What the fuck?
white
Wait,
dragon with blue eyes.
who was the bad guy in Peacemaker? I'm telling you, his name is like White Dragon Peacemaker.
But
Yeah. Okay, it's just White Dragon.
But I'm looking at the chat now, and I get it. The right is cheating right now. Texas is cheating, but I think you guys are coming in with a bigger advantage than polls would suggest. I think the Republicans get mopped in the fucking midterms unless this California shit happens. I think this is a way that you fumble that bag, and it becomes harder for the public to make a difference. Because I get the joke that Gavin Newsom is doing is awesome and hilarious if you're paying attention. But for the majority of the public that's not, they're like, oh, well, the Democrats are now just doing the same stuff as Trump.
Well, we'll see. Like I said, I'd be down to have that conversation because obviously I support it. Because I don't think that we. I think obviously we're favored to win the midterms. I'm not sure that holds true because it's not just Texas. Florida's lining up to do it. Ohio as well. I don't have nearly as much confidence in the Democrats that you do, that you think that if they gerrymander in like 5 red states that we can overcome those odds. But we'll definitely have a conversation about that in the future. But where can people find you in general?
Yeah, so it got harder as of recently, but Jebtan RIP on Twitter. I do have a Twitch, Jebtan. It is currently banned for anti-French racism that I stand by in a chat. But
literally,
yeah.
he made a joke about France, and that's what got him kicked off.
And
so.
in context, it was very funny. Charlie was talking about how when people of color say that they hate white people, they're not talking about all white people. And so I just wanted to clarify in her chat that when I say I hate the French, I mean every single one of them. And I might have called them, someone might have called them dirty sewer rats at some point. I'm
not sure it's possible to be racist against the French. I think it's like saying those dirty Americans, those dirty Canadians, whatever. So that's interesting that you caught a ban for that. But listen, I appreciate this. I could talk about this for 3 more hours, but that's the problem. And I'm trying to demonstrate some impulse control. And I appreciate you being good faith, bro, even though we disagree on this.
Yep.
And yeah, man, I appreciate it. I'll catch you around. We'll try to have some sort of conversation about the gerrymandering thing.
Sounds good.
All right, bro. Thank you. All right, chat. Appreciate you guys. And I'll make sure to link Jebtan's stuff to the chat. But yeah. All right, folks. Appreciate you. Thank you. I'm off to hang out with the wife.